How on earth can it be justified that there is, quote, no reason for immediate custodial sentence in a case like this where a man was repeatedly slashing a large knife towards another man out in public in retaliation and revenge and aggression for what he was doing? He also spat at him and kicked at him, and yet he's received a suspended sentence. This was the case you'll be familiar with where another man was burning the Quran in public, and this man here chose to take action and revenge against him. Now, I make a firm caveat at the outset of this video. I don't agree with the actions of burning the Quran or any religious book for that matter. It is not a criminal offense, however much people think it should be. It is not. That's not to say that I agree with it. Saying that it is not unlawful is not me saying that I agree with it. However, the revenge attack here was quite clearly unlawful. But in an age where we say that we are standing, or we should be standing firm against knife crime, and we want to stamp it out, send a strong message that any knife crime should result in people going to prison, this result tends to run directly against that objective. So with great respect to the judge, I don't think a lot of the British public will agree with this decision. Nonetheless, I will go through the sentence remarks here. This is how the judge justified it, but me showing you the justification is not the same as me agreeing with it, and I'm not saying that you should. Maybe you do, maybe you don't, but nonetheless, the remarks are here. So please do subscribe to my channel if you like these legal updates, and let's dig into this. So the judge addresses it. Mr. Kadri, I have to sentence you today for two matters: possession of a bladed article in a public place and common assault. Now, that is because there was no, as I understand it, no actual contact with the knife. Nonetheless, it was a bladed article in a public place, and he was repeatedly slashing this knife towards him. The judge said, the offences to which you've pleaded guilty occurred on the 13th of February near Turkish consulate in central London. You were clearly deeply offended by a man who was protesting outside the consulate, who was part of this protest, set fire to the Holy Quran. You were heard to issue threats against him, calling him an effing idiot, telling him that you were going to kill him, then returned inside your property. When you came back outside, you'd armed yourself with a knife and went to confront him. Now, pausing for thought for a moment there, the fact that he left and came back to the scene was obviously a premeditated attack with the knife. Whether he actually injured him with the knife or not is irrelevant. He came back with the knife after threats to kill. Reading on, what happened next was graphically recorded on CCTV and showed what, to any passing member of the public, must have appeared to be a very frightening and violent attack in the street by a man armed with a knife. You slashed towards the other man, and when he went to the ground, you kicked him a number of times and spat at him. These events must have been very frightening indeed for members of the public to observe. Whilst I accept that the blade in question may not have been the same in league, say as a sharpened kitchen knife, it appears to be a pointed bread knife. It was pointed and could have caused serious injury. Now, just as a very brief point of law there have been many cases on whether or not a knife is sharp or not. One such case involved a butter knife, and the judge said we'd invite all sorts of mischief if in every single case we argued about whether the knife was sharp. So a bladed article, it doesn't matter whether it's sharp or not, it can still be a bladed article, such as a butter knife. And in this case, I understand it was a bread knife. The judge went on to say, even if you never had any intention to stab him, your actions in public in central London during the day were wholly unacceptable. Knife crime of any sort is something that these courts take extremely seriously. When armed with a knife, there's always the possibility that a really serious injury or death, even if unintended, could result. Losing your temper and your self-control in that way as you did on that day is disgraceful and is something that I know you are rightly ashamed of. I accept that you're remorseful as reflected in the references and the pre-sentence's report that I've read. I note, however, that you're now 59 years old and someone hitherto exemplary character. Apart, obviously, from the video that you just saw. Those who know you speak extremely high of you and observe that this behaviour is totally out of character, which maybe you accept it probably is. Those observations demonstrate what a tragedy it is that a man of your previous good character should find that because of your actions you are before the Crown Court for the first time in your life. I note also the good works you do, especially work with charities. Turning to sentencing guidelines, this is something that I frequently reference in my videos. The judge said both these offences occurred together, so were bound with each other. It's therefore entirely appropriate that I take each one of them, the bladed article offence, as the lead offence and reflect the circumstances of the assault in the sentence I pass on that count. In other words, if two different offences, one very much less serious, occurs at the same time on the same factual matrix as the other one, they are dealt with together. If one goes to the Crown Court, they all go to the Crown Court. They're dealt with together and sort of subsumed into the same story and dealt with in any sort of sentence by way of the lead offence. And then there is a decision as to whether they are consecutive or concurrent sentences together or one after another. Usually concurrently, unless there's a good reason to separate them out, usually by way of different events occurring at different times and so on. The judge, as I just said, then says, it follows that in my judgment, concurrent at the same time sentences are appropriate in this case. I accept the categorization agreed by the prosecution and defense in this case, having considered the appropriate sentencing guideline. For the blade, the starting point for a culpability A, harm 2 offence is 6 months, with a range between 3 months and 1 year in custody. The fact that you sought to mislead those investigating this case by sending a photograph of a palette knife, something that you were clearly not carrying, is an aggravating factor. So he tried to mislead the court by showing a picture of a different knife. I understand that you do not contest this. That and the circumstances of the assault lead, in my judgment, to an upward adjustment from the starting point of 6 months. Turning to the mitigation, I've observed, I note you're a 59 years old man of previously exemplary character. You're a loved husband and father, hard worker, someone who those have written on your behalf cannot praise highly enough. You're relied upon as a carer, much respected in your work and charity. Mr. Unwin, who's spoken so eloquently on your behalf this morning, urges me to impose a community order in your case, but I cannot. This case clearly crosses the custody threshold, as you might expect it would. The use of blades is a curse on our community. There cannot be separate standards based simply on the type of person who chooses to behave this way. There has to be, it seems to me, a clear message that these courts take this type of offence extremely seriously and that prison sentence will be imposed. That said, in your case, I see no reason for that sentence to result in immediate custody. So to me, that's sort of contradictory, with great respect to the judge, if as a community we say knife crime should send people to prison, and yet in this case there is no reason for the sentence to result in immediate custody. It's somewhat contradictory, and I respectfully disagree with it. The judge says, I've already observed that your mitigation reflects a highly respected and valued individual, despite previously saying it shouldn't matter what type of person behaves this way. He goes on to say the same thing. I accept your remorse, and I accept that there is almost non-existent chance of repetition of this behaviour. I'm not really sure I accept that either, because if this were to happen again, just because he's been prosecuted this time, what's to say that won't happen again? And just particularly because he's not actually gone to prison, although next time he would go to prison, so that might be deterrent next time. The effect of your incarceration now on others would be wholly disproportionate, because the court does consider others in its judgment passing sentence. So the judge said, I propose, therefore, to impose a suspended sentence of imprisonment for 18 months. Had there been a trial, having taken all the circumstances and offences and the aggravating factor into consideration, and having balanced that against the mitigation advanced, the sentence would have been one of 6 months. Giving you credit of between 20 and 25% to reflect your plea, I reduce that to one of 20 weeks. For the common assault, it'll be 6 weeks running at the same time. And so that is suspended for 18 months. So the judge then says, you will do what you are told to do in the next 18 months. If you commit another offence or fail to meet the requirements given to you by your probation officer, you'll be brought back to court. In the first instance, the magistrate's court, where the order could be made more onerous by the imposition of further days or hours or a fine, or if you're not going to comply at all, with the sentencing being activated whether in part or in whole, i.e. the 20-week sentence would then be activated either in part or in whole, if he were to do something wrong in the next 18 months. The judge says, I impose a statutory surcharge of the appropriate amount and award the prosecution costs of £150 to be paid by you within 28 days from now. So as I say, I think there's a lot of people that won't agree with this. I can see the judge's reasoning. I can explain the reasoning to you. You can probably see and understand the reasoning, but you possibly don't agree with it. On the one hand, there's mitigation in the sense that of his age and previous good character, and other people that say he's of good character, that it's out of character for him. He helps with charities. He does a lot of good work. Other people speak very highly of him. He's a carer. Other people will suffer as a result if he does go to prison, etc. But on the other hand, we say that we should be dealing with knife crime extremely seriously. This other man could well have been injured seriously, even fatally, even if that wasn't intentional by this man here. So because of that, we say that we should deal with knife crime, any form of knife crime, or even if that is merely, as it was here, possession of a blade, which is coupled with the assault. Because had he been wounded, obviously that would have been an unlawful wounding. So I do think a lot of people will see this, that we should be taking this extremely seriously, particularly when it is contrasted with cases such as Lucy Connolly, who had a 31-month immediate imprisonment imposed just for sending out a post which was said to have been stirring up racial hatred, which she deleted a few hours later. There's all sorts of discussions over her pleading guilty and so on, and she said that she felt oppressed to plead guilty, all the rest of it. When you compare the two and the general stance against knife crime, this probably, to me, I think a lot of people, let me know in the comments, I think a lot of people just won't agree with the outcome of this case. And to that end, Robert Jenrick has written to the Director of Public Prosecution, said, "I'm writing to ask plainly, why was he charged as it was?" So, in other words, why was it charged so lightly, as in just possession of the blade and assault? He says, on the footage and the admitted words, the sequence is clear. He confronts him outside the Turkish consulate, says, "I'm going to kill you," leaves and returns armed with a knife, makes repeated slashing motions pursuing him, and once he was on the ground, spits at and kicks him. He then tells the police he was protecting his religion, yet the case proceeded on common assault and simple possession of a bladed article, producing a suspended term. This is where I say you don't always blame the judge, because you look at what the sentencing guidelines say, but then there's also the element as to whether it gets suspended or not. Robert goes on and asks, were Section 139AA, which is threatening with a bladed article, and Section 16 offences against the person, threats to kill, considered and rejected? If so, on what evidential basis? Why was no religiously aggravated count added, given the stated motive? Because it was obviously quite clear that he was defending his religion, so it was obviously racially motivated in this events here. He says, was ABH, Section 47, considered in light of the pursuit, the kicks and the spits, and any injury evidence? He says, who took the charging decision? What materials before them, including the video? And how was the Code for Crown Prosecutors applied to a knife-enabled reprisal aimed at silencing lawful expression in the public place? He said this was a landmark case where significant violence was deployed to oppress the victim's right to freedom of expression, primarily because of the attacker's religious views. The effect of the charge selection was so to constrain both sentence and review. That is a matter of public confidence as much as law. He says, I ask you to set out the CPS written instructions in full. When a man arms himself and deploys violence to shut someone up, the law must bite. If the CPS will not use the tools Parliament has given it, I will promptly put this before the House. Those are Robert Jenrick's comments. So leave me your thoughts and comments in the box below. This seems to me that it may well not have been charged properly in the first place, which somewhat tied the judge's hands in it, but also the ultimate sentence, one of a suspended sentence, you may not agree with either. Let me know what you think in the comments below. And of course, thank you for watching.